Good day, everyone. I am J. Mark D. Bukog from BS Criminology 3 Delta. Today, we are going to continue our last activity 8C from page 21 to 30. Title 1, Felonies and Circumstances which affect criminal liability of the crime. Okay? The judge should impose the law. Dura lex sed lex. The most that he could do is recommend to the chief executive to grant executive clemency. Paragraph 2 does not apply to crimes punishable by special law, including profiteering and illegal possession of firearms or drugs. There can be no executive clemency for these crimes. Article 6, consummated, frustrated, and attempted felonies. Consummated felonies, as well as those which are frustrated and attempted, are punishable. A felony is consummated when all the elements necessary for its execution and accomplishment are present, and it is frustrated when the offender performs all the acts of execution which would produce the felony as a consequences, but which nevertheless do not produce it by the reason of causes independent of the will of the perpetrator. Okay? There is an attempt when the offender commences the commission of a felony directly or overacts and does not perform all the acts of execution which should produce the felony by reason of some cause or accident other than his own spontaneous desistance. Development of a crime. Number 1, internal acts. Intent and plans usually not punishable. Number 2, external acts classified into 2, A and B. A, preparatory acts tending toward the crime. Letter B, acts of execution, acts directly connected to the crime. Mere intention is therefore not punishable for as long as there is no physical form of the internal acts. The same is outside the inquiry of criminal law. Okay, let's proceed to another topic. The stages of commission of a crime. First, the attempted. Overt acts of execution are started. Not all acts of execution are present. Frustrated. All acts of execution are present. Crime sought to be committed is not achieved due to intervening causes independent of the will of the perpetrator. Let's go to consummated. All the acts of execution are present. The result sought is achieved. Let's go to another topic. The desistance. Desistance on the part of the offender negates criminal liability in the attempted stage. The three criteria needed to identify whether a felony is attempted or frustrated. Number 1, the manner of committing the crime. Number 2, the elements of the crime. And number 3, the nature of the crime itself. Article number 7, when light felonies are punishable. Light felonies are punishable only when they have been consummated, with the exemption of those committed against person or property. A light felony in violation of a penal law, which is punished by penalty of imprisonment of not more than 30 days or arresto minor of a fine of not more than 200 pesos or both upon the discretion of the court. Examples of light felonies: slight physical injuries, theft, 5 peso or less alternation of boundary, marks, alarms, and scandals, simple slander, malicious mischief, not exceeds 200 peso, and entry going against honor. That was light felonies. Okay, let's go to article number 8, conspiracy and proposal to commit felony. Conspiracy and proposal to commit felony are punishable only in the cases in which the law specially provides a penalty. Therefore, a conspiracy exists when two or more persons come to an agreement concerning the commission of a felony and decide to commit it. There is a proposal when the person who has decided to commit a felony proposes its execution to some other person or persons. Conspiracy is punishable in the following cases: treason, Article 115, rebellion or insurrection, Article 134, sedition, Article 139, coup d'etat, Article 134A, arson, Article 320, Presidential Decree 1613, and monopolies and combinations and restraint of trade. Okay, let's go to next page, page 23 of the book. Number 1, with the title of Felonies and Circumstances Which Affect Criminal Liability. Number 1, mere conspiracy to commit a crime is not punished except in treason, rebellion, or sedition. Even then, if the treason is actually committed, the conspiracy will considered as a means of committing it, and the accused will all be charged for treason and not for conspiracy to commit treason in Article 115. Number 2, and proposal, not only the person proposing or the proponent is criminally liable in Article 306. Two ways of for conspiracy to exist in Article 8. Two kinds of conspiracy. Two kinds of conspiracy. Number 1, conspiracy as crime, Article 115 to Article 134. And number 2, conspiracy as manner of incurring criminal liability, Article 8. When conspiracy itself is a crime, no overt act is necessary to bring about the criminal liability. The mere conspiracy is the crime itself. This is only true when the law expressly punishes the mere conspiracy. Otherwise, the conspiracy does not bring about the commission of the crime, because conspiracy is not an overt act but a mere preparatory act. Treason, rebellion, sedition, and coup d'etat are the only crimes where the conspiracy and proposal to commit them are punishable. Let's go to composite crimes. Composite crimes are crimes which in substance consist of more than one crime, but in the eyes of the law, there is only one crime. For example, the crimes of robbery with homicide, robbery with rape, robbery with physical injury. In case the crime committed is a composite crime, the conspirator will be liable for all acts committed during the commission of the crime agreed upon. As a general rule, when there is conspiracy, the rule is that the act of one is the act of all. This principle applies only to the crime agreed upon. The exemption is if any of the conspirators would commit a crime not agreed upon. Exemption to the exemption in acts constituting a single indivisible offense, even though the co-conspirator perform different acts bringing about the composite crime. All will be liable for such crime. They can only evade responsibility for any other crime outside of that agreed upon if it is proved that the particular conspirator had tried to prevent the commission of such other act. Okay, let's go to next page, page 24. Compendia of Revised Penal Code, Book 1 and Book 2, Article 9. Article 9, grave felonies, less grave felonies, and light felonies. Grave felonies are those to which the law attached the capital punishment or penalties which in any of their period are afflictive in accordance with Article 25 of this code. Less grave felonies are those which the law punishes with penalties which in their maximum period are correctional in accordance with the above mentioned article. Light felonies are those infractions of law for the commission of which a penalty of arresto minor or a fine not exceeding 200 pesos or both is provided. Capital punishment, the death penalty, penalties, imprisonment. Grave, 6 years and 1 day to reclusion perpetua or life imprisonment. Least grave felony or least grave, 1 month and 1 day to 6 years. Light, arresto minor, 1 day to 30 days. Felonies are classified as follows according to the manner of their commission under Article 3. They are classified as intentional felonies or those committed with deliberate intent, and culpable felonies or those resulting from negligence, reckless imprudence, lack of foresight, or lack of skill. Number 2, according to the stages of their execution under Article 6, attempted felony, frustrated felony, consummated felony. Article 10, offenses not subject to the provision of this code, offenses which are or in the future may be punishable under special law are not subject to the provision of this code. This code shall be supplementary to such laws unless the latter should specially provide contrary. For special laws, penalties should be imprisonment and not reclusion perpetua, etc. Offenses that are attempted or frustrated are not punishable unless otherwise stated. Plea of guilty is not mitigating for offenses punishable by special laws. No minimum, medium, and maximum periods of penalties. Okay, that's it for the page. Okay, let's go to page 25. No penalty for an accessory or accomplice unless the otherwise stated. Provision of Revised Penal Code applicable to special laws. Number 1, Article 16, participation of accomplices. Number 2, Article 22, retroactivity of penal laws favorable to the accused. Number 3, Article 45, confiscation of instruments used in the crime. The crime of cattle rustling is not a mala prohibitum but a modification of crime theft of large cattle. So, Presidential Decree 533 punishing cattle rustling is not a special law. It can absorb the crime of murder. If in the course of cattle rustling, murder was committed, the offender cannot be prosecuted for murder. Murder would be a qualifying circumstances in the crime of qualified cattle rustling. See people or Martinada. Okay, let's go to another topic, the circumstances affecting criminal liability. There are 5 circumstances affecting criminal liability. Number 1, justifying circumstances. Number 2, exempting circumstances. Number 3, mitigating circumstances. Number 4, aggravating circumstances and alternative circumstances. There are 2 other which are found elsewhere in the provision of the Revised Penal Code. Number 1, absolutory cause and extenuating circumstances. Absolutory cause, the effect of this is to absolve the offender from criminal liability, although not from civil liability. Number 1, Article 20, it provides that the penalties prescribed for accessories shall not be imposed upon those who are such with respect to their spouses, ascendants, descendants, legitimate, natural, and adopted brothers and sisters or relatives by affinity within the same degrees with the exemption of the accessories who profited themselves as assisting the offender to profit by the effects of the crime. Number 2, Article 89 provides how criminal liability is extinguished. Letter A, death of the convict as to the personal penalties and as pecuniary penalties liability. Therefore, it is extinguished if death occurs before final judgment. B, service of the sentence. C, amnesty. D, absolute pardon. E, prescribing of the crime. F, prescribing of the penalty. And last, G, marriage of the offended woman as provided in Article 344. Let's go to number 3. Under Article 247, a legally married person who kills or inflicts physical injuries upon his or her spouse whom he surprised having sexual intercourse with his or her paramour or mistress is not criminal liable. Under Article 219, discovering secrets from seizures of correspondence of the ward by their guardian is not penalized. Number 5, under Article 332 is the case of theft, swindling, and malicious mischief. There is no criminal liability but only evil liability when the offender and the offended party are related as spouse, ascendants, descendants, brother, or aunt, and sister-in-law living together, or where in case the widowed spouse and the property involved as is that of the deceased spouse before such property had passed on the possession of third parties. Number 6, under Article 344, in cases of seduction, abduction, acts of lasciviousness, and rape, the marriage of the offended party shall extinguish the criminal action. 7. Any person who entered another's dwelling to prevent serious harm to himself, the occupants of the dwelling of a third person rendered some service to humanity or justice, or entered cafes, taverns, inns, and other public houses while the same were open in Article 280, Paragraph 3. Absolutory cause has the effect of exempting circumstances and they are predicated on lack of voluntariness like instigation. Let's go to page 27 of our book, titled Felonies and Circumstances which Affect Criminal Liability. Instigation is associated with criminal intent. Do not consider culpa. In connection with instigation, if the crime is culpable, there is no instigation. In the instigation, the crime is committed with dolo. It is confused with entrapment. Entrapment is not an absolutory cause. Entrapment does not exempt the offender or mitigate this criminal liability, but instigation absolves the offender from criminal liability. Difference between instigation and entrapment. Okay, in instigation, the criminal plan or design exists in the mind of the law enforcer with whom the person instigated cooperated. So it is said that the person instigated is acting only as a mere instrument or tool of the law enforcer in the performance of his duties. On the other hand, in entrapment, a criminal design is already in the mind of the person entrapped. It did not emanate from the mind of the law enforcer entrapping him. Entrapment involves only ways and means which are laid down or resorted to facilitate the apprehension of the culprit. In case of somnambulism, somnambulism, or one who acts while sleeping. The person involved is definitely acting without freedom and without sufficient intelligence because he is asleep. He is moving like a robot, unaware of what he is doing. So the element of voluntariness, which is necessary is dolo and culpa, is not present. Somnambulism is an absolutory cause, or if elements of voluntariness is absent, there is no criminal liability, although there is civil liability, and if the circumstance is not among the enumerated in the Article 12, refer to the circumstances as an absolutory cause. Mistake of fact is an absolutory cause. The offender is acting without criminal intent, so in mistake of fact, it is necessary that had the facts been true as accused believed them to be, this act is justified. If not, there is criminal liability because there is no mistake of fact anymore. The offender must believe he is performing a lawful act. Distinction between justifying circumstances and exempting circumstances. In justifying circumstances, 1. The circumstances affects the act, not the actor. Number 2. The act complained of is considered to have been done within the bounds of law. Hence, it is legitimate and lawful in the eyes of the law. Number 3. Since the act is considered lawful, there is no crime, and because there is no crime, there is no criminal. Number 4. Since there is no crime or criminal, there is no criminal liability as well as civil liability. In exempting circumstances, the circumstances affects the actor, not the act. Number 2. The act complained of his actually wrongful, but the actor acted without voluntariness. He is a mere tool or instrument of the crime. Number 3. Since the act complained of is actually wrongful, there is a crime, but because the actors acted without voluntariness, there is absence of dolo or culpa. There is no criminal. Since where is crime committed but there is no criminal, there is civil liability for wrong done but there is no criminal liability. However, in the paragraph 4 and 7 of Article 12, there is either criminal nor civil liability. Let's go to Chapter 2, Justifying Circumstances and Circumstances which exempt from criminal liability. Article 11, Justifying Circumstances. The following do not incur any criminal liability. Number 1, anyone who acts in defense of his person or rights, provided that the following circumstances occur: A. First, unlawful aggression. B. Second, reasonable necessity of means employed to prevent or repel it. Third, C. Third, lack of sufficient provocation on the part of the person defending himself. Number 2, anyone who acts in defense of person or rights of his spouse, ascendants, descendants, or legitimate, natural, or adopted brothers or sisters, or his relative by affinity, in the same degrees and those consanguinity within the fourth civil degree, provided that the first and second requisites prescribed in the next preceding circumstance are present in the further requisites, and in case the revocation was given by the person attacked, that the one making defense had no part therein. Number 3, anyone who acts in defense of person of rights of a stranger, provided that the first and second requisites mentioned in the first circumstances of this article are present, and that the person defending be not induced by revenge, resentment, or other evil motive. Number 4, any person who, in order to avoid an evil or injury, does not act which causes damage to another, provide that the following requisites are present. A. First, that the evil sought to be avoided actually exists. Second, the injury feared be greater than the done to avoid it. C3. Third, that there be no other practical and less harmful means of preventing it. 5. Any person who acts in fulfillment of a duty or in the lawful exercise of a right or office. 6. Any person who acts in obedience to an order issued by a superior for some lawful purpose. Okay, let's go to another topic. The rights included in self-defense. Defense of person, defense of rights protected by law, defense of property. The owner or lawful possessor of a thing has a right to exclude any person from the enjoyment of disposal thereof. For this purpose, he may use such force as may be reasonably necessary to repel or prevent an actual or threatened unlawful physical invasion or usurpation of his property. In Article 429 New Civil Code. For the defense of chastity elements, unlawful aggression is a physical act manifesting danger to life or limb. It is either actual or imminent. A. Actual or real aggression. Real aggression presupposes an act positively strong showing the wrongful intent of the aggressor, which is not merely threatening or intimidating attitude but a material attack. There must be real danger to life or personal safety. B. Imminent unlawful aggression. It is an attack that is impending or on the point of happening. It must not consist in a mere threatening attitude, nor must it be merely imaginary. The intimidating attitude must be offensive and positively strong. To give a rise to self-defense, the aggression must not be a lawful one like the attack of a husband against a paramour of his wife, whom he surprised in a uncompromising situation, or a chief of police who threw stones at the accused who was running away to elude arrest of a crime committed in the presence. Their aggression was not considered unlawful. Where there is an agreement to fight, there is no unlawful aggression. Each of the protagonists is at once assailant and assaulted, and neither can invoke the right of self-defense because aggression, which is an accident in the fight, is bound to arise from one or the other of the combatants, exemption where the attack is made in violation of the condition agreed upon. There may be unlawful aggression. Unlawful aggression in self-defense to be justifying must exist at the time of the defense is made. It may no longer exist if the aggressor runs away after the attack or he has manifested a refusal to continue fighting. If the person attacked allowed some time to elapse after he suffered the injury before hitting back, his act of hitting back would not constitute self-defense but revenge. The unlawful aggression must come from the person who was attacked by accused. It follows that when the source of the unlawful aggression is not known, the unlawful aggression cannot be considered present in the resolution of the case. This observation is true only in self-defense, obviously, if cannot apply to defense of relatives and strangers. A light push on the head with the hand is not unlawful aggression. Not a foot kick greeting is not unlawful aggression, but a slap on the face because his dignity is in danger is unlawful aggression. A police officer exceeding his authority may become unlawful aggressor. Okay, that's it. The last page, page 30. Thank you so much, sir. That's all. Thank you.